Well, good evening, everyone. I am so sorry about the first recording. I do not know why I'm having so many audio issues. I've been trying a new microphone, and a video I did the other day also didn't save the audio, so I ended up having to re-record that. So here is me now re-recording the updates on the Texas docket, the Wallace v. Lively case. I have got a bit of a sore throat, so my voice may break a little bit. So we've had a few things happen. I will cover from the start the original. So as a motion was filed for a proposed scheduling order by Jed Wallace back in July. Lively responded. Then to fully complete the brief, Jed Wallace then issued a reply to Blake Lively. And I haven't done any content on that, so I'll just read them because they are short letter motions, and then I will go through the judge's order. So we will start at the beginning. This is the original motion filed by Jed Wallace. It's dated the 18th of July, and it says, Plaintiffs Jed Wallace and Street Relations respectfully move the court pursuant to Federal Rules of Civil Procedure 16 and Question 10 of this court's fact sheet for an order requiring the parties to confer and submit a proposed scheduling order. In support of this motion, plaintiffs state as follows. On February 4th, 2025, plaintiffs filed their complaint for declaratory judgment and defamation against Defendant Blake Lively. Defendant moved to dismiss the complaint on April 7th. Plaintiffs subsequently filed their amended complaint on April 24th, dropping their claim for declaratory judgment, after which defendant filed a motion to dismiss the amended complaint. Briefing on defendant's motion to dismiss was complete as of June 23rd, 2025. Since 16th of June, plaintiffs have made multiple attempts to engage defendant in a conference pursuant to Federal Rules of Civil Procedure 26F and to reach agreement regarding a joint request for an initial status conference. Today, we were informed by defendant's counsel that defendant does not agree to scheduling a Rule 26F conference at this time because defendant does not believe that discovery should occur in this matter until after the court determines if this case is properly before it. We disagree. So my first point on this. It is ironic. I haven't read, obviously I'm reading this as it is in front of me, but obviously in the New York case, twice Jed Wallace filed a motion to stay discovery on the basis that, well, the complaint against him may be thrown out. Twice Blake Lively opposed that, and twice Blake Lively got her way when Judge Lyman agreed with her. So here that has been flipped. Blake Lively is the one that has a pending motion to dismiss, and she is saying to Jed Wallace, well, we don't know if this case is going to sit before this court, so I would rather hold off on discovery until we know. And Jed Wallace is saying, no, I was forced to go through discovery, even though I was initially dismissed before you refiled. I still have to go through discovery. So I do find that quite it's amusing to see this. How it gets, watching these two do battle in two different dockets under two different judges is, with their count where their points turn on their head. It's quite amusing. Question 10 of this court's fact sheet asks, what is the court's procedure for issuance of scheduling orders in civil cases? The response to that question, as provided by the court, is the court will send the parties an order requiring them to confer and submit a proposed scheduling order to the court. Failure to submit a proposed scheduling order within the court's 30-day deadline will result in the court issuing its own order. In light of the above, plaintiffs respectfully request that the court enter an order requiring the parties to confer and submit a proposed scheduling order in accordance with the court's procedures. As to the issue of a status conference, Defendant's counsel states that the defendant is not opposed to requesting a status conference as long as it is at a mutually convenient time. Wherefore, plaintiffs Jed Wallace and Street Relations Inc. respectfully request that the court 1. Enter an order requiring the parties to engage in a Rule 26F conference and to submit a proposed scheduling order to the court, and 2. Set a status conference. Plaintiffs further request such other and further relief as the court deems just and proper. Okay. So, yeah, this is a certificate of conference. So this is basically certifying that, look, we conferred, and Blake Lively's counsel said we don't agree to a Rule 26F conference. So he's just confirming that for the benefit of the judge. Now, Blake Lively did actually reply. She got to oppose. Let's have a look. Right. Defendant Blake Lively files this response to plaintiff's motion for an order requiring the parties to confer and submit a proposed scheduling order to the court, and shows the following. Both parties agree with requesting that the court hold an initial status conference. Despite this, plaintiffs have filed a motion to compel, asking the court to mandate that the parties engage in a Rule 26F conference for the sole purpose of starting discovery in a case over which many threshold issues remain impending. So, whether the first file rule demands dismissal, whether there is personal jurisdiction over Miss Lively, whether venue is proper in this district, and whether the plaintiff's sole defamation claim has merit. See defendant's motion to dismiss the amended complaint. Judge Lyman has squarely addressed the merits of this claim brought by plaintiffs herein for defamation arising out of Miss Lively's filing of a CRD complaint, and held that there is no cognizable claim for defamation because the statements made therein are privileged as a matter of law. Now, what she is basically saying to the judge is, Judge, we don't need to do discovery because they've only got a defamation claim. And Judge Lyman in New York, he's already made a decision on that in New York. So, and that should apply here. That is what she's doing. She's like, don't worry yourself with this, Judge. Forget about it. It's going to fail because Judge Lyman already says so. Now, obviously, my perspective, obviously, of that is I do think Jed Wallace is going to have a hard time. I do. Because the ruling, as far as the law goes, that decision was right. CRD was filed. And she did anticipate litigation because she did actually then bring a claim to New York. Now, if litigation privilege applies, and then as far as the CRD being used then in the New York Times, the reporting privilege applies, then Jed Wallace is going to have a hard time. However, I don't love the fact that she's like, well, saying to a federal district judge in Texas, don't worry about it. The judge in New York, my friend over there, he's already decided on your behalf. That's the bit that's bothering me. Plaintiffs refer to their multiple attempts to engage Miss Lively's counsel in a conference when counsel has heard nothing from the plaintiff since the week of June 16th, when counsel was out of the country. Instead, plaintiffs have focused their attention on the first filed case in Southern District of New York, engaging in a multitude of filings involving discovery disputes and refusing to produce Plaintiff Wallace for a deposition. And we have a footnote. Plaintiffs have repeatedly represented in the Southern District of New York that Plaintiff Wallace's current health condition prevents him from fully engaging in discovery, which further begs the question of why the rush to start discovery in this case. I don't love that she didn't redact that. I don't love that she did not redact that bit of information. For me, it's like, it's referring to medical status. And I don't think there was a need for that to be shared with the public. Gosh, you wouldn't have liked that if someone had put that on there, given this woman withdrew her intentional distress claims because she didn't want to have any information about her mental state, her psychology treatments and various things obtained and potentially becoming public. I don't like how she keeps blasting out Jed Wallace's health problems. In the intervening time in Texas, the Hill Country, more specifically Hunt, Texas in Kerr County, experienced catastrophic flooding resulting in the loss of more than 100 lives. Lead counsel for Miss Lively has property and family and, like others, has lost people she knows in the flood-ravaged community of Hunt, Texas. Okay, I remember that. I have so much sympathy for the people that were affected by those floods. However, the irony here, right, that Blake Lively's lawyer has been affected by flooding, and, there should be some kind of that should be taken into consideration when Blake Lively absolutely refused to grant any kind of an extension to Brian Friedman, Wayfarer's counsel, when not just Brian Friedman, but some of the Wayfarer defendants themselves lost their homes. They were evacuated. Brian Friedman lost his law offices in the Palisades fires. Remember that? How completely unsympathetic she was, refused to grant any kind of extension to compensate for what he had lost in those fires. So I'm a bit, well, you won't consider it yourself. So why should anyone show you consideration now? Okay, still after a month of silence, plaintiff's counsel reached out by email on July 17th, imposing an arbitrary deadline for response of the next day at noon, despite being advised that counsel was out of town with intermittent connectivity. Fortunately, Miss Lively's counsel was able to respond to the arbitrary demand by noon the next day and sent the following email. Hi, Carl. I hope you're doing well. I'm out of town at the moment and have intermittent internet, but I'm not opposed to requesting a status conference as long as it is at a mutually convenient time. We do not agree to scheduling a Rule 26F conference at this time because we do not believe that discovery should occur in this matter until after the court determines if the case is properly before it. If you're putting together a motion, we would appreciate the opportunity to review prior. Thanks and take care, Laura. Okay. Plaintiffs responded by filing of an unnecessary and mislabeled motion to compel. As previously indicated, Ms. Lively does not oppose an initial status conference with this court. What she does oppose is starting discovery at this time, while preliminary issues of jurisdiction and venue are yet to be decided, and when Judge Lyman has ruled that defamation claims arising out of Ms. Lively's CRD complaint, the exact claim raised herein, lack merit and cannot survive a Rule 12b6 motion. So again, judge has already decided, why do I need to do discovery? So that I just think is absolutely ridiculous. Okay, so Jed Wallace did file a brief reply. Okay. Plaintiffs Jed Wallace and Street Relations, Inc. Submit this reply to defendant's response to plaintiff's motion regarding the Rule 26F conference and the request for initial status conference. Plaintiffs note that, notwithstanding the parties' differing views on the timing of discovery, both sides agree that an initial status conference with the court would be beneficial. Plaintiffs believe that such a conference is the appropriate forum to address any outstanding issues, including those raised in defendant's response and her recent motion styled as a notice, and to establish a constructive path forward for this case. Plaintiffs do not believe it is necessary or productive to engage in further debate regarding the points made in the defendant's response. Instead, plaintiffs are committed to working cooperatively with all parties and with the court to resolve preliminary matters in a professional and respectful manner. Accordingly, plaintiffs respectfully request that the court set an initial status conference at its earliest convenience, and that any other issues raised by the parties be addressed at that time or as the court deems appropriate. And then, so that was all briefed by the 22nd of July. Now, we had this order on the 23rd of October. I'm not going to read it all word for word because it's telling them what kind of, what he's looking for in this proposed scheduling order. So I won't read that, but I'll just read this bit. At the request of the bar, the district judges have implemented a procedure whereby a magistrate judge is assigned to each civil case at the time it is filed. The assignments are made randomly and are evenly divided among magistrate judges. If a pretrial matter is referred by the district judge, it will be handled by the magistrate judge to whom the case was assigned. Similarly, if the parties consent to magistrate judge jurisdiction, the case will be placed on the docket of the assigned magistrate judge for all future proceedings, including entry of judgment. The United States magistrate judge assigned to this case is the Honorable Howell. Okay. So, it is hereby ordered that the parties shall submit a proposed scheduling order to the court within 30 days from this order. Obviously, this order is dated the 23rd of October. The parties shall first confer as required by Federal Rules of Civil Procedure 26F. The content of the proposed scheduling order shall include proposals for all deadlines set out in the form for scheduling order attached hereto and contained in Appendix B to the local rules. The parties shall endeavour to agree concerning the contents of the proposed order, but in the event they are unable to do so, each party's position and the reasons for the disagreement shall be included in the proposed schedule submitted to the court. In the event the plaintiff has not yet obtained service and all defendants, the plaintiff shall include an explanation of why all parties have not been served. The scheduling proposals of the parties shall be considered by the trial court, but the setting of all dates is within the discretion of the court. The parties shall indicate in the proposed order that they have in fact conferred as required by the Federal Rules of Procedure. And then it goes on to list a bunch of suggestions, which I won't read through. So he has basically, Blake Lively did not get her own way with this judge. So he has granted Judge Wallace's proposed scheduling order. And this is a Appendix B, which is obviously like a template that they should use. Okay, so it's so nice to be able to read an order which does not go in Blake Lively's favour one way or another. So yeah, and it's also, like I say, it's this docket has been so quiet, I completely forget about it at times. But I do enjoy covering this one a lot, because I love comparing how what Blake Lively says in one docket to what she says in another one, where she's making an almost identical claim. And it's been many times in various videos or live streams when I've sort of said, well, she says this in New York, but in Texas, you know, she's usually more bolder with her claims, or they're more exaggerated. And I find that amusing to watch in real time. And I'm going to leave it there because I'm now getting hiccups. So thank you for watching and have a good weekend.